Can my significant other come to the United States on a visit visa? We get married and file for adjustment. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. In 2025, it's taking longer and longer for spouses and fiancés to get to the United States. So some people are thinking to themselves, well, I'm pretty smart, I'm pretty clever. I'm just going to have her or him or they enter the United States on a visit visa. And once they're here, we'll just get married and then we'll file for adjustment because I heard those green card cases are going a lot faster. Now, indeed, they are going faster. But one of the things that you're seeing now in 2025 with a spike in the delays of visa processing is you're also starting to see requests for evidence, notices of intent to deny, and Stokes interviews on the issue of what the plan was when the boyfriend or girlfriend came to the United States on a visit visa. What do I mean by that? Well, for the first time since I started practicing immigration law back in 2008, we are seeing a spike in these requests for evidence from USCIS. They are pushing back. They want to know, was this the plan all along? Did this person who's now sitting across from me asking for a green card, did they have immigrant intent? Did they sell all their earthly belongings? Did they quit their job? Did they close up shop? Did they sell their house or run their lease to the end and then come with all their earthly possessions to the United States on a visit visa? Now, I had someone on the Immigration Answer show yesterday talking to me and asking me, well, Jim, I know that I can file for them as a fiance and bring them here that way because we've been in each other's physical presence and we're willing to get married within 90 days of arrival. That's one option. Another option would be to get married and file an I-130 petition with USCIS and then wait for the National Visa Center to complete its processing and then send the case to the consulate for interviews. But I've heard that can take over 2 years. So what we're thinking is, she already has a visit visa. Why not have her come to the United States and then we'll get married? We'll wait 60 days, no problem. Now, I'm here to tell you that I've been seeing requests for evidences, notices of intent to deny, and we've had people on the show tell us that they were given a Stokes interview on the specific issue of what was the intent of the immigrant when they came to the United States. Did they have that intent? Was their plan all along to get a green card? Was their plan all along to get married and try to jump the line from all the other people waiting either at USCIS or the National Visa Center or the State Department? These cases are still approvable. This does still happen, but it all comes down to the immigrant's intent. Did they have the intent when they came to come visit? Did they have a return ticket? Did they still have their life back home? And then when they got here, something happened in their lives where maybe somebody broke their leg or something happened or they have a real reason to sort of change the plan that they had before? That can still be approved. But if they come dragging all their earthly possessions across the border at the international bridge, or if they pack up their belongings and try to get on a plane to come to the United States and they say to CBP, hey, I'm just here for a visit, but really they have that intention of staying forever, they're going to be in big, big trouble. What do I mean by that? Well, their green card will not be approvable. The I-130 petition for an alien relative will probably be approved. They'll say, yeah, we believe this marriage, but you had immigrant intent when you came on that visit. You didn't tell us about your immigrant intent. You told us you were coming for 30, 60, 90 days or 6 months. You told us that you were going to leave at the end of your visit, but you didn't, and you didn't have the intention of doing that. And because you didn't have the intention of doing that, you made a misrepresentation. And if you hadn't made that misrepresentation, we might not have let you in, but we let you in because you were lying to us and we thought you were telling the truth. And because you lied to us, you now need a waiver. You have made a misrepresentation to obtain an immigration benefit, namely entry into the United States, and for those reasons, you are ineligible for adjustment of status, and you are going to have to file an I-601 waiver, and you're going to have to demonstrate to the satisfaction of USCIS that if we kick your butt out of here and send you back to your home country like we want to and like we should, that it's going to create an exceptional hardship on your spouse. Not just that it's going to be hard for them because you're living overseas, not just going to be hard because they're going to have to come visit you. It has to be an exceptional hardship. There's something about your spouse and their hardship, their health conditions, their mental health conditions, their psychological conditions, their economic conditions, their living situation. That means that we should forgive you for misrepresenting yourself. So I think there's going to be a real sea change here in the months to come. And with USCIS looking to enforce the law as strictly as they can and to be left wing of ICE, and to help ICE find as many people as possible, got to hit that quota. Stephen Miller wants 3,000 people deported a day. Well, we're a better place to find immigrants than people at USCIS, especially those who lied their way into the United States. That's their mindset. That's their philosophy. If you're thinking about going through the green card process, if you just got married or you're considering your options and you want to hire our firm to help with you, we'd be happy to help you with a fiance case, with a spouse case, even an adjustment case here in the United States when the beneficiary entered on a visit visa. We handle all those kinds of cases. We've seen these situations many, many times, including citizenship and asylum. We'd love to work with you. Give us a call at 314-961-8200. Email us info@hackingimmigrationlaw.com. If you're just looking for free resources, you can join us in our free Facebook group. It's called Immigrant Home. We'd love to have you join us there. We have our YouTube channel that I post 3 or 4 new videos a week on. And we have our Immigration Answers live show, which is different than the standalone videos. That's a show where we just take calls from immigrants who are asking about the immigration process. We'd be happy to talk to you about that. And you can access that by either subscribing to the YouTube channel, looking for us on Facebook, or you can send us the word show to 314, text the word show to 314-470-3300, and you'll get an alert when we go live. Thanks so much for watching. We'll see you on the next video.